Welcome to the EPA Alumni Association Academy presentation, an update on litigation affecting EPA. We all know that since the advent of the current administration, there's been a veritable blizzard of litigation, much of which has the potential to affect EPA either directly or indirectly, with numerous short-term and long-term stays of administrative action, decisions overruling stays, the burgeoning of the Supreme Court's so-called shadow docket, and the beginning of a new Supreme Court term. There's an awful lot going on. The panel will give us a better sense of what's going on and hopefully some educated predictions about what's to come, particularly with regard to the endangerment finding at the Supreme Court. But things are moving fast, and today's program can only give a snapshot of what's going on. After all three panelists' presentations, there'll be an opportunity for questions from the audience using the chat function. And a video recording of this program will be made available via the Alumni Association website. So let me now very briefly introduce our panelists. You already have their bios, but I'll start with John Cruden. John's no stranger to Academy presentations. Now in private practice, John has had an extraordinary career at the Department of Justice, serving in key positions in the Environment and Natural Resources Division, culminating in his service as Assistant Attorney General for ENRD. During his career, John has been a stalwart supporter of EPA and environmental programs. Professor Sanne Knudsen teaches at the University of Washington Law School, where she's the Stimson Bullitt Endowed Professor of Environmental Law. Now, we all know when there's a name in the title of a professor, it's a big deal. Early in her career, she clerked for the Honorable Ronald Gould, a very well-respected member of the Ninth Circuit Court of Appeals. Professor Robert Percival has also spoken to the Alumni Association before. He's the Robert F. Stanton Professor of Law. Remember what I said about having a name in the title? And director of the Environmental Law Program at the University of Maryland. Bob's the author of the most popular environmental law textbook. He's been a visiting professor at institutions around the world and has served in a variety of important institutions in the environmental law field. Now I'll ask John to take over and begin the presentations.
Bruce, thank you very much for that kind introduction. I am honored doing something like this with two of my great friends, both Bob and Sanne, who are two of the most distinguished law professors and court watchers. And I think all of us agreed to do it because we honor you. All of you have served so well at EPA. We have turbulent times right now, but that does not mean we should overlook the enormous contributions that each and every one of you made during your service. Okay, we're going to do the Supreme Court in kind of like a nutshell. You know, there's a lot of things going on. This is it. These are the nine. This is your Supreme Court. This is the Supreme Court that brought you West Virginia versus EPA as a major case doctrine. This is Supreme Court that brought you the Sackett decision, which narrowed the coverage of waters of the United States. This is the Supreme Court that overruled Chevron in Loper Bright. And so there's no question that they've been in the news. There's no question they have no reluctance to take big cases. Here's what we're going to do during our time with you. I'm going to start out with statistics because I love to do that. I just enjoy telling you about what's happening there. Then we're going to do the big cases of last term in the environment arena. And then we'll do this term, starting out with cases that you won't see because cert was not granted, and then the cases where cert has been granted. We'll do all that, and each one of us will be coming in and out. All right, look at this one. These are how old they are there. You know, go there and find out. Look at the right-hand side. You see that Trump, right, he's got the most appointees. 3 of them are his appointees. There's some people thinking he could get 1, possibly 2 more, if, during his 4-year term. Bob Percival tells us that there are, justices out there writing opinions because they're kind of auditioning for the Supreme Court. Bob, you have any idea, any predictions as, if Trump got a pick, where he would go?
Well, I don't think he's going to get a pick because I think Alito's enjoying himself too much being in the majority all the time. And Thomas wants to set the all-time record for longevity. And when Leonard Leo said, if you want them to retire to open up new vacancies for Trump, you're treating them like meat with an expire by date on. So I don't think that's going to, but there have been so many Fifth Circuit judges like Judge Ho, who I'll talk about his opinion in the NRC case, um, but they seem to be taking positions, even some that they didn't take before, in order to make it clear that they would vote with Trump on almost anything.
Okay, let's go to the next slide where we do just give you an overview. I'm only going to highlight a couple of things. First of all, I teach at George Washington University, they're always astonished that still there's a lot of unanimous decisions. Last term, 42% of them were unanimous. You got to be careful about that number, as we'll see when we get to 7 County. When 7 County said it was unanimous, it wasn't at all there. But it's the upper right-hand corner there, 9%. Those are the ones that are really getting the attention. Those are the 6-3 opinions that everybody watches. All right, now next slide is the question is we ask it all the time. We ask it of ourselves. This is what lawyers do. Whose court is it? And by the answer to that is not always the Chief Justice. When Kennedy was a concurrent was the deciding vote, or Justice Day O'Connor was the deciding vote. It was kind of their court because they were making the decision. Look at this one. There is no question who's in the majority the most, and it's Chief Justice. And this slide has been the same the last 3 or 4 years. Why is that important? He decides who writes the opinion. Every single time he is in the majority, he's senior, he is picking who writes that opinion. As you'll see when we start talking about the opinions, that can become very important. The next slide is like one of my favorites. We call this paired voting. What does that mean? That means what's the likelihood that the 2 justices are going to vote the same there? You have to know very little about the Supreme Court to guess that Jackson and Thomas don't vote together the same very much. But who does? Again, this is a statistic that's been pretty stable for the last 3 or 4 years, without question, Roberts and Kavanaugh. And so, if you can figure out how Roberts and Kavanaugh are going to vote on a particular case, you probably have a pretty good idea who's going to win the case. So that was paired voting. Let's do the next slide there. This is kind of my circuit slide. This one is different than other years. I used to say that I thought there was a special box in the Supreme Court marked reverse, and it was for the Ninth Circuit cases coming up. But that wasn't true this last year, was it? Take a look at that long green. That's the Fifth Circuit. That's the Fifth Circuit. They had 13 cases, 10 of them reversed. Who's next? Ninth Circuit? No. It's not at all. There, you got the Fourth Circuit. Now, the Ninth Circuit still got all their cases reversed there, but nonetheless, you're seeing a switch, right? You're seeing a switch in where these cases are coming from, and then how the circuits are being treated. All right, with that in mind, where you have your belly full of Supreme Court statistics, let's do the real things. Let's start going into some of the big cases of last term. And the first one is one that my law firm did, but I'm going to turn it over to Sanne because she's better doing it than I am.
Okay, thanks for that introduction and those statistics. That always helps ground us. So this first case is a Clean Water Act case. No doubt some of the folks in the audience have heard of it. It's an opinion written by Justice Alito. Chief Justice Roberts, Thomas, Kavanaugh joined. So that's 4 votes for the entire opinion. Justice Gorsuch joined in all parts but part 2. So that's 5 votes for everything but part 2. Justices Sotomayor, Kagan, and Barrett and Jackson dissented in part, but then they joined part 2, which then puts us back at 5 votes for part 2. So if you're following me at all, it basically means there's 5 votes for the entire opinion coming from various factions. So now you might be thinking, uh-oh, the last time Justice Alito penned a Clean Water Act opinion, it was Sackett versus EPA. And we were told that the act was a potent weapon, and that the agency's concerns about wetlands destruction and water quality were mere policy considerations. The act was narrowed, obviously, in Sackett in its jurisdictional reach, and we were left with the distinct impression that the Clean Water Act was viewed with some general disdain by the court. This case was different, though. Justice Alito's opinion was written in a what I'll call a refreshingly neutral tone. And that was perhaps because the issue presented did not involve questions of wetlands permits and the potential imposition of a federal statute on private development and land use. By comparison, this case was much less exciting, no offense, John, and was born out of a much less dramatic regulatory history. Because this case dealt with a municipality and traditional pollution control permits. So those permits, known as NPDES permits or National Pollution Discharge Elimination System permits, tell dischargers, like here, the city of San Francisco, how much of any given pollutant they're allowed to release into receiving waters, which here was the San Francisco Bay or the Pacific Ocean. So when the permitting agency, either the EPA or the state, writes one of these permits, we know they're supposed to keep their eye on 2 things: technology and water quality standards. The easier of these things is technology, and when writing those permits, you have to consider the technological capabilities of the industry seeking the permit and set numeric limits accordingly. And those are known as TBELs, or technology-based effluent limits. But the Clean Water Act also allows permitting to impose what are called QBELs, and these are water quality-based effluent limits. These limits allow permitting agencies to keep their eye on and protect ambient water quality, which is the whole point of the act. So QBELs are important components of permits because sometimes cumulative impacts from multiple sources means that a receiving water is at risk of degradation despite technology setting the limits for individual dischargers. So that's all to say that this case centers on QBELs, the limits that protect water quality standards more directly. And in writing the city of San Francisco's combined storm and wastewater discharge permit, the EPA and the state of California did not reduce their concerns about water quality standards to any rate, concentration, or quantity. And that is what is at issue here, right? They did not reduce their concerns to a numeric standard or a number. Rather, the EPA wrote what the court termed end result requirements into the permit. In particular, EPA prohibited the city from making any discharges that, quote, contributes to a violation of a water quality standard. For this permit, the permit that was at issue, known as the Oceanside permit, the receiving water was the Pacific Ocean. And so the end result requirement essentially said, don't violate any water quality standard applicable to the Pacific Ocean. So the permit also instructed the city not to violate any state nuisance laws. Justice Alito observed that the city could face stiff penalties for violating either of these permit conditions, including criminal penalties. And this is something that he raised in Sackett as well, and appears to be a recurring theme in his concern about fairness with regard to the Clean Water Act. So that's one to hold on to. But not surprisingly, the city of San Francisco objected to these end result requirements. They said, sure, you can protect water quality standards, but you have to reduce your concern to a numeric effluent limit. You have to do the work and translate the outcome you desire into an actual numeric standard. The Ninth Circuit disagreed and sided with EPA here. It held that the act allows permitting agencies to impose other limits, and that those other limits could be written broadly, like the end result requirements that were written into the Oceanside permit. Well, the Supreme Court grants cert and reverses. It accepts some of the city of San Francisco's arguments and rejects others. On the one hand, the court rejected the city's kind of most extreme argument, which is that all cue bells have to be reduced to a numeric limit. In that part of the opinion, which was this part 2 that got only some factions, but nevertheless 5 votes, the court hewed closely to the text of Section 1311, which speaks both to effluent limits and any more stringent limitation. And the use of the word effluent in one part, but not another part of that section, Justice Alito explains, means that Congress meant to authorize EPA to impose effluent limits and other limits, which is to say non-numeric limits as well. So in this part of the opinion, the court rejects the idea that all cue bells have to be numeric limits. It's okay for those limits to be narrative as well. Okay, so that's part 2, where the court rejects this more extreme version of the city's argument. But then the court goes on to accept the more moderate reading of the statute, namely that even if non-numeric limits are acceptable, they simply can't say and don't violate water quality standards. The court agrees that the permitting agency has to do the work to tell the permittee in more specific terms, whether that's numeric or narrative, of what it can and cannot do. So again, here Justice Alito focuses on the text of the statute, but he also considers the structure and the pre-enactment context of the statute, and he also keeps in mind the purpose of the statute. I said, earlier in writing this opinion that Justice Alito strikes a neutral tone. Consider that he arrives at his statutory interpretation in this case by looking at the text and the structure and the history of federal water pollution control legislation. And on multiple times throughout this opinion, he observes that water quality will not suffer under his reading of the statute, right? He simply says that the EPA must do the work. So on the one hand, this seems maybe unremarkable that you would look at the water quality protection purposes of the Clean Water Act when interpreting it. But I think it's noteworthy given the ease with which he had previously swept aside that broader purpose of the Clean Water Act in Sackett. Before I move on, I'll simply note here that the dissenters, led by Justice Barrett, would have accepted the entirety of the Ninth Circuit's decision and the EPA's position. They would have upheld the end result requirements as being supported by the text of the act. Justice Barrett, in fact, calls the majority opinion's logic wrong as a matter of ordinary English. She says that limitations can be general or specific, that conditions can be written into many levels of generality, and that the majority reads too much into Congress's use of the term limitation when it insists on a certain degree of specificity. So, after reading Justice Barrett's dissent next to Justice Alito's majority opinion, on this one, I think we might observe that the court actually found a middle ground in this case, one that it thought strikes the balance between fairness to permittees, which was obviously on the mind of Justice Alito, and the driving the water quality purposes of the act. So I think they thought that they got the balance of this one right. Okay, I think we'll go on now. I've got you guys for the 7-county case too. So I'm going to go on, and this is no doubt another case that's been in the news quite a bit. 7-County Infrastructure Coalition versus Eagle County. This one's a NEPA case. Okay, so for this one, I like to say if you're a cynic, that's probably all you need to know if you want to predict the outcome of this case. right? NEPA has a distinct track record at the Supreme Court. Before Seven County, the track record was 0-17 for NEPA, and now make that record 0-18. Justice Kavanaugh here writes this decision. Roberts, Thomas, Alito, and Barrett join. Justice Sotomayor filed a separate opinion concurring in the judgment, in which Kagan and Justice Jackson joined, and then Justice Gorsuch recused himself. Ultimately, there were 8 votes for the government, 8 votes for reversing the DC Circuit, 8 votes for narrowing the reach of NEPA. And so that's why this one gets called a unanimous opinion. But as John mentioned earlier, you shouldn't think of it as a unanimous opinion. As far as the logic goes, you really could think of this case as a 5-3. There is quite a separation between Justice Kavanaugh's and Justice Sotomayor's opinions in the stories that they tell of NEPA and the breadth of their decisions. I'm going to focus on Justice Kavanaugh because he's in the 5, and so his logic is going to carry the day. But he writes a broad opinion. Parts of it feel almost advisory and even hostile to the core of NEPA. Sotomayor, she sticks to the question presented and to the facts, and I think she strikes a more restrained tone on this one. The dispute here centers on a proposed 88-mile railroad line in northeastern Utah. The rail line would connect crude oil from the Uinta Basin, which is roughly the size of the state of Maryland, to the interstate freight network. And then it would make it easier to transport that basin's crude oil to refineries in Louisiana, Texas, and other places. Right now, the transport's by truck along mountain passes and narrow roads. And so the idea is to enhance the efficiency and the safety of this transport of the crude oil. In analyzing the impacts of this proposed project, we have the Surface Transportation Board, and they produced an environmental impact statement that was over 600 pages, 3,600 pages if you count appendices, which is what Justice Kavanaugh does. But the STB approved the project in December 2021. Not surprisingly, a group of environmental organizations and a Colorado county sued in the DC Circuit. They argued that the STB needed to do a fuller analysis of, in particular, the potential upstream and downstream impacts of the rail line. Upstream impacts included the increased drilling in the Uinta Basin. Downstream impacts included the increased refining of crude oil in those southern refineries. The STB, which did do some upstream and downstream impact analysis, they nonetheless maintained that they didn't have to do that kind of analysis because they had no control and no regulatory authority over potential oil and gas development and then refineries. The DC Circuit agreed with the environmental groups, though, and vacated the STB's approval of the project, said they had to do more. So the Supreme Court granted cert. Now, on its face, you'd think that Seven County would be a case about the reach of the Supreme Court's 2004 opinion in Public Citizen, which is the one that says that NEPA review is limited when an agency lacks control over certain impacts. But you'd be wrong, because in short, Seven County is about course correction. Those are Justice Kavanaugh's words. As you know, NEPA is procedural only, but procedure has proven to be a powerful tool in the environmental review context. NEPA has long been used as a tool for delay by project opponents. And as a result, in response to and in anticipation of litigation, the length and complexity of environmental review has grown over the years. So much so that Justice Kavanaugh laments that NEPA reviews have gotten too involved and have caused too many delays, and courts, he said, have taken too heavy of a role in deciding what and how much agencies have to say about environmental consequences of proposed actions. So what to do? Well, in Seven County, Kavanaugh tells us that the bedrock principle of judicial review in NEPA cases can be stated in a word: deference, he says. Yes, the DC Circuit erred on the question of upstream and downstream effects, and public citizen does play a role here. We will get to that, but more fundamentally, the DC Circuit erred in its approach, in its attitude. That's what Kavanaugh says. He says courts should afford substantial deference and should not micromanage agency choices about scope, depth, length, and content of environmental review, so long as, he says, they fall within a broad zone of reasonableness. So pause here a moment. How does the court's call for deference square with Loper-Bright, the case decided about a year and a half ago that overruled Chevron and swore off agency deference on questions of statutory interpretation? Does Seven County undo Loper-Bright? In a word, no. Loper-Bright supplies the standard of review for questions of law. For issues of statutory interpretation, Loper-Bright tells us that lower courts are supposed to use their independent judgment to determine the best reading of a statute. NEPA cases, however, don't typically pose questions of statutory interpretation, Kavanaugh says. Rather, they pose questions of mixed law and fact, questions of implementation, questions rooted in the facts of a particular project. And for many of these questions, he says the rule of reason governs. In fact, the rule of reason is a guiding principle in NEPA because the text of NEPA is lean compared to many other environmental statutes. Much of its meat and structure over the years come from court decisions and implementing regulations. That means there's relatively little text to justify the kind of intensive environmental analysis that has come to define NEPA, or at least that's the theory. It also helps to understand that NEPA itself does not supply a cause of action. So anyone who's challenging an agency decision on NEPA grounds has to do so through the Administrative Procedure Act, or the APA. Well, the standard of review under the APA is arbitrary and capricious, and that's a deferential standard. So that means that this call for deference in 7 counties is consistent with arbitrary and capricious review. At the same time, arbitrary and capricious review is also known as hard look review, or has given way to the hard look doctrine, right? Meaning that some courts will roll up their sleeves and ask critical questions about the reasons that an agency gives for its action. And because of that, this arbitrary and capricious review can accommodate a range of judicial attitudes, from more scrutinizing to more forgiving. So at the end of the day, we can think of 7 County as refining the arbitrary and capricious standard as applied to NEPA cases. And with that refinement, Justice Kavanaugh says, be deferential. Now, by calling for deference, 7 County no doubt weakens judicial review of NEPA claims and thus has the potential to weaken NEPA. At the very least, the court puts the fate of NEPA and the strength of environmental review in the hands of agencies tasked with performing that review. I will look to NEPA review as a place that will be susceptible to whipsawing in the future between presidential administrations. I think while individual agency regulations may temper this a bit, currently agencies are rolling back their NEPA regulations, and there's going to be more room for executive orders to set the tone for how much agencies should look before they leap in the future. Couple other things about 7 County. The case is not just about course correction. The case narrows NEPA review in a few other respects as well, and I'm going to just highlight 3. First, 7 County narrows the responsibility of agencies to consider impacts beyond their proposed projects. So the court says agencies don't have to consider environmental effects of separate projects, even if those effects are foreseeable. An agency only needs to consider effects of the project at hand. Asterisk, that still includes indirect effects. But for anyone familiar with the longstanding CEQ regs in effect during prior presidential administrations, you'll note that this is quite a change. Both federal courts and CEQ regulations have historically required agencies to consider impacts beyond the proposed project, namely cumulative impacts and also impacts from connected actions. Both of those concepts would require looking beyond the narrowly defined proposed project. And curiously, Justice Kavanaugh does not mention those regulations or those concepts in Seven County. One reason might be that the CEQ actually issued an interim final rule in April 2025, rescinding all of the government-wide regulations implementing NEPA. And they did that in response to President Trump's executive order on unleashing American energy. Even so, many of the CEQ regs or guidance had followed case law that helped push the CEQ regs. And so I still find it a little bit curious that Justice Kavanaugh didn't mention kind of those longstanding concepts when kind of issuing this course correction in Seven County. So second point here is simply that public citizen did play a role here. The court also said that, it's not just that this was the upstream and downstream impacts involved separate projects based on public citizen. It was also the fact that the agency didn't have control over those impacts. And so there is part of the opinion that taps directly into public citizen, but it is kind of one piece of the opinion, not the main show. Justice Mayor, she actually hews more closely to the public citizen question, and that's how she would have resolved this entire case. Last point I'll make is that Seven County's narrowing of NEPA also has to do with remedy. At one point, Justice Kavanaugh remarks that even if an EIS falls short in some respects, it doesn't necessarily mean that there should be a vacatur, unless you believe that the agency might actually disapprove of the project if it were to go back and add more. I like NEPA, so I will say this seems to be where Justice Kavanaugh would have benefited from discussing the very point of NEPA, which requires agencies to look before they leap on the humble presumption that we don't know what we don't know. So in the end, not surprisingly, Seven County has already had an impact. Several courts have already applied Seven County to narrow NEPA's reach and defer more aggressively to agencies. Courts have refused to give injunctive relief. They have said that agencies are not required to evaluate separate projects. They've deferred to agencies' evaluation of alternatives. They've deferred to agency decisions to rely on categorical exclusions. They've deferred on whether supplemental NEPA review was necessary. So I think that the lower courts are really taking the breadth of this opinion to heart and approaching NEPA review with the deference that Justice Kavanaugh called for in his course correction. Okay, with that, I will turn this over to Bob to talk about the Nuclear Regulatory Commission and Judge Ho.
Okay, this was a case involving the question of whether or not the Nuclear Regulatory Commission has the authority to license offsite storage facilities for high-level radioactive waste. The original plan, I mean, when we embarked on building all these nuclear reactors before we had figured out how to solve the waste disposal problem, but it was always argued, well, we're going to have 30 to 40 years to figure out a solution to that because that will be the useful life of these nuclear power plants. And the Nuclear Waste Policy Act originally contemplated that the federal government would build 2 permanent repositories for high-level radioactive waste. This is the waste that comes out of nuclear power plants. It's really dangerous, can be very dangerous for thousands of years, perhaps, so it's quite a challenge. And the original scheme was that there would be one repository located west of the Mississippi River and one located east of the Mississippi River. But when DOE was considering sites, it started looking like by far the best geological formation for high-level radioactive waste storage would be in granite formations. And New Hampshire, the granite state, has most of them, but the Republican presidential primary in 1988 featured Vice President George H.W. Bush running against Pat Buchanan, and Buchanan made a big issue out of this during the New Hampshire primary. And as a result, DOE suddenly announced, well, we really don't need two repositories. Let's just build one, and we'll build it west of the Mississippi River. The site that DOE sort of honed in on was Yucca Mountain, Nevada, which now, mind you, almost all the nuclear power plants are in the eastern United States. Nevada has no nuclear power plant, and yet it ended up getting kind of shafted by the other states when DOE said, we're going to go full speed ahead on Yucca Mountain. But what's happened is that so much waste is being generated by the existing nuclear power plants. And since we don't have a licensed high-level repository to send it to, it's mostly building up in pools at existing nuclear power plants, which is not all that safe. And so the NRC said that it would entertain applications for licenses for interim storage facilities. And it held a licensing proceeding and granted a license to Interim Storage Partners, a private company that wanted to build offsite interim storage in Texas. Texas didn't like that because it thought that wherever they end up sticking the waste will de facto become a permanent repository. And so Texas and a private party challenged the authority of the Nuclear Regulatory Commission to issue an interim storage license. Now, one procedural problem is that the Hobbs Act, also known as the Administrative Orders Review Act of 1950, permits judicial review at the behest of any party to a licensing proceeding. Texas did not actually participate as a party to the licensing proceeding before the NRC. It did, along with one private party, comment on the environmental impact statement. And so one procedural question was whether or not a non-party could seek judicial review of an NRC decision. And the Fifth Circuit said there should be an exception to the Hobbs Act in circumstances where the agency has acted ultra vires, where it didn't have the authority to do something that it did. When it got to the Supreme Court, the justices ruled 6-3 with Gorsuch, Thomas, and Alito dissenting that the Hobbs Act barred judicial review of the NRC's decision because neither the state of Texas nor this private party, Fasken, had actually been interveners that were admitted as parties to the licensing proceeding. The majority said submitting comments on the EIS is not enough to make you a party. And the justices all rejected the Fifth Circuit's ultra vires argument that somehow there was an exception to the Hobbs Act if the agency had acted without authority. The justices said it has to be contrary to a specific prohibition in the statute. And here, the NRC wasn't claiming any new authority. They had already granted 10 offsite licenses for storage to other parties. And so the court on procedural grounds was able to dodge the question of whether the Atomic Energy Act actually authorizes the NRC to issue
licenses for interim storage. Justice Gorsuch, in his dissent, said you can only store such waste on federal land or at private property where it's on site. But the majority of the justices rejected that. So for now, at least, the NRC is free to go ahead and continue to issue these interim storage licenses. The next case doesn't sound like an environmental case, but it has very important implications for environmental law because it was an effort to revive the non-delegation doctrine. In 1980, while I was actually clerking on the court, in the famous benzene case, the court split 4-1-4 with Justice Rehnquist, the one who said, I think the entire Occupational Safety and Health Act is, in fact, a violation of the non-delegation doctrine because it's not specific enough in directing OSHA as to how stringently to regulate. Now, there was also, all 8 other justices rejected that. And in 2001, in the American trucking case involving the Clean Air Act and National Ambient Air Quality Standards, industry groups had thought that they could piggyback on Rehnquist's position in the benzene case and get the court to hold, as a panel of the DC Circuit did, that the Clean Air Act violated the non-delegation doctrine because it had no intelligible principle to guide EPA in determining how stringently to regulate in the National Ambient Air Quality Standards. Now, the implications of that for environmental law would have been breathtaking because the Clean Air Act is one of the more detailed statutes. It has a whole procedure for how you consult with the Clean Air Scientific Advisory Committee and decide to set new national ambient air quality standards. So there in American trucking, even Justice Rehnquist refused to take up the non-delegation grounds that he had argued so forcefully for 21 years before. Now, the actual case, FCC versus Consumers Research, involved challenges to what's called the Universal Service Fund. In 1996, the Telecommunications Act of 1934 was amended to require telecommunications companies to contribute to what's known as a universal service fund, the money of which is to be used to help ensure that people in rural areas have good telecommunications services. And it creates a private entity that decides at what level to set that level of contributions to the Universal Service Fund. And those who are intent on reviving the non-delegation doctrine thought this was a great vehicle for doing so. And so they were greatly disappointed by the outcome. They had argued that even though the Fifth Circuit panel had rejected non-delegation claim, the Fifth Circuit en banc had reversed. And so they thought with the Fifth Circuit on board, we might finally get the non-delegation doctrine revived. Now, I asked my classes, why is the non-delegation doctrine like the late Detroit Tiger pitcher Mark the Bird Fidrich? And the answer is that it only had one good year. Fidrich was a rookie sensation in 1976. Even though he didn't start the season in the majors, he won 19 games, pitched 24 complete games, and then got injured and never had any great success in the majors after that. So the answer is that, like the non-delegation doctrine, Fidrich had only one good year, because the only times the courts used the non-delegation doctrine to strike down acts of Congress were in these 2 New Deal cases, Panama Refining Company versus Ryan and Schechter Poultry, where the court said that you have to have some intelligible principle to guide the agency in deciding how it's going to implement a statute. And the court had no problem here in consumers research saying that the act does have intelligible principles that are enough to guide the exercise of discretion. Now, there was an effort to try to get the court to buy into a private non-delegation theory, the idea being that if you have both a broad delegation and the involvement of private parties here, the group that set the amount of contributions, that somehow made the non-delegation doctrine more salient. And yet the court majority rejected that argument. They said there's no such thing as a private non-delegation doctrine. However, Kavanaugh did, in a concurring opinion, say delegations to independent agencies. Oh, no, my computer was going to sleep. To independent agencies raise more serious non-delegation problems. But here, he found that the degree of accepted discretion delegated varies with the scope of the power. They tried to say this is a tax and therefore it's different. The majority rejected that. But Kavanaugh signaled that in the future, if it was a delegation to an independent agency, that he might be more sympathetic. The dissenters here again were Gorsuch, Thomas, and Alito. And of course, this coincides with, we'll talk about it in the context of the shadow docket. The court's already signaled that it's going to overrule Humphrey's executor, a 90-year-old decision that allowed for-cause removal restrictions on members of independent agencies. And we'll talk about that when we talk about the shadow docket. So, kind of dodged a bullet here, and hopefully this will put to rest, at least for a while, efforts to revive the non-delegation doctrine and then say so many of our environmental statutes violate it because they give EPA and other agencies too much discretion. So, John.
Well, let's turn to standing. Come on, what would a Supreme Court term be without a good standing decision? And all of you in the audience your eyes are rolling right now because you remember all the other standing cases where some environmental group is trying to figure out how they have standing to cut down challenge forest issues or challenge something else, and this is not that case. This is refineries challenging the California's zero emission vehicle program. So you got entirely different issues, entirely different, and the lineup is different. The only thing that's particularly predictable about that is that they're going to reverse the Ninth Circuit. That's the only thing predictable about this decision. In any case, the argument by the refineries is kind of straightforward in many ways, and that is, well, if you use all electricity and you don't use gas, we're refineries, we're going to lose money. Well, I'm sure that's true there, but that was not the position that held in the lower court, because the lower court and in the Supreme Court, the other parties argued, no, that doesn't make any difference because the auto industries were going to do it anyway. They were going to do it anyway, so it really didn't make any difference if there was a ZEV standard. Well, that did not go. This is a standing case, 7-2. Thomas wrote it and said, no, I'm sorry, Kavanaugh wrote it. A 7-2 decision and said, no, if you have economic injury, that's enough there. When I first read it, I thought, well, that would be interesting for environmental groups. But Jackson wrote a dissent saying, this doesn't help environmental groups much at all. But one interesting aside for all of you who, saw, this particular case coming up is that this was the 160th argument by Ed Needler. And all of you, many of you listening to us now if you didn't know Ed, you knew the name, because for many, many years, he was a senior career person, and he was a gatekeeper on environmental cases. And Ed then ultimately had the record of the most Supreme Court arguments, 160 cases that he argued there. And at the end of it, I've never seen this before, but at the end of his argument, he got a standing argument, because it turns out that many of the justices had actually worked with him in the Solicitor General's office, to include Roberts and Alito. But did that make any difference in the case? No. They ruled against him in that case. There. Let's do the next one. We're going to turn to a couple of cases that are all about venue. These are all those sorts of decisions, and I know that in the audience we have a number of you that did the Clean Air Act, and probably like me, when you're lecturing to people, you always explain, why does the DC Circuit have so many of the Clean Air Act cases? And we all said, because that's what the law says. The law says, interestingly enough, a venue provision, that those cases that are of national jurisdiction, those cases go to the DC Circuit. Of course, the flip side to that is, if it is a so-called state or regional case, then it goes into some other circuit. Well, these were fights over which are they national in origin, or in application, or are they local in application? And they are both in different ways in important cases. The first one, this one, Calumet, is those low producing refineries, small refineries. They've been up before the Supreme Court before, and of course they want to be local. This was a Louisiana case. Louisiana case got denied. They want to be in Louisiana. The argument of the government was, no, this is a national jurisdiction. Thomas wrote both of the opinions. They were decided the same day. Both this one, Calumet, and the case I'll talk about in a second, both decided the same day. So they're kind of flipped of both, but they do really bring teeth to these decisions. And we saw them before. We've seen these arguments in the Sixth Circuit when they were doing Waters of the United States. The Court of Appeals have the decision, or does District Court? And we're seeing the same thing now under Clean Air Act cases. And so Thomas goes through a whole process of saying, well, yes, if it's a national jurisdiction, yes, it goes to the DC Circuit. But even if it's a local or state, it could still end up in the DC Circuit if the application, if the implementation has nationwide. And that's what he decided here. In this particular case, 7-2, decided, yet even though the rule, which is a single refinery case in a single state, even though that looked like it was local in nature, the decision affected all of the refineries, and therefore it was national jurisdiction. Let's go to the next slide, and we'll do the flip side of this. This is Oklahoma versus EPA, but for so many of you that have seen the up and down of the Good Neighbor Rule, this is one more edition of the Good Neighbor Rule. Last term, the Supreme Court also did the Good Neighbor Rule, and they also found problems with the issues. In that case, Gorsuch writing it, so that it went back to EPA, and here is now looking at just the issue of whether or not this is going to be something that goes to the DC Circuit, or is it going to go to go through a local court? You kind of think, if you're writing on Good Neighbor Rule, that's a rule that applies to everybody, and therefore it ought to be something that the DC Circuit said there. But as Thomas got into it, he pointed out, no, because even though EPA impacted 21 states, every state got an individual analysis. It was highly factual in the Good Neighbor Rule, whether or not they were going to accept what the state was offering as the National Ambient Air Quality Standards or not. And because it was individualized, that meant that it was going to go locally and not go to the DC Circuit. So we have two decisions. In both cases, the lower courts get reversed. but we now have pretty much a pretty steady body of law as to the application of something we all know well, and that is whether or not a Clean Air Act case, all rulemaking goes to the DC Circuit or not.
Well, in the Oklahoma case, I think Deputy Solicitor General Malcolm Stewart had the best line of the year, where Oklahoma had been complaining that it was unfair to have this in DC. And he said, if location in DC meant that the DC Circuit is a hometown court for EPA, then this court would be a hometown court for EPA. And I've never had that perception, which produced laughter from the audience.
Oh, yes, me too. All right, let's go next.
So the shadow docket cases, the court this has been the major transformation of the court in recent years. And it all started for environmental cases back when the Clean Power Plan was challenged, and the court shocked everyone by going over the head of the DC Circuit panel that had unanimously denied a stay and granted a stay. So the Trump administration ended up bringing more emergency motions to the court than all the previous administrations combined. And an example of that, the Trump versus CASA, that's the birthright citizenship case. The amazing thing about this was the Trump administration refused to take it up on the merits. Instead, they said, we want to challenge the fact that a universal injunction was issued. Most legal scholars say the Constitution is so clear, right in the text of the 14th Amendment, people born in the United States become U.S. citizens. But by only taking it up on the procedural point of whether or not it was proper to issue a nationwide injunction, the court, instead of just resolving this issue and ending all confusion, just said no universal injunction unless it's absolutely necessary to give relief to the parties. And the other thing that the Trump Solicitor General did was they've now taken the position that anything that delays Trump being able to do something he wants to do causes irreparable harm. That's a completely different view in the normal balancing of the equities. So they would do things like be able to completely abolish the education department without even hearing argument on the merits. So the last I saw, Trump was 19 for 19 in getting the court to enter stays when he wanted to stop something a lower court judge was doing. The 20th was something where it ended up becoming mooted out because of subsequent legislation. But his track record is truly amazing, which, especially given that this court struck down a lot of Biden administration initiatives, it doesn't actually seem like there's a level fit playing field at the Supreme Court now. So cases in, yeah.
I want to jump in there on that shadow docket just for a second and just note that the court is no doubt aware of kind of the perceptions here, because in that Trump versus CASA case, you had Justice Barrett kind of beginning her opinion there by noting that objections to universal injunctions was not unique to the Trump administration, right? She said that the court on multiple occasions and across, administrations, the Solicitor General had asked the court to consider the propriety of that expansive remedy. And then she goes on and she cites a bunch of scholarship noting that kind of by the end of the Biden administration, nearly all major presidential acts had been frozen by a federal court, right? Like Obama administration, it was the 2015 WOTUS rule that was stayed by the Sixth Circuit. And then the Texas District Court stayed Obama's DAPA policy. So I just thought it was interesting that Justice Barrett really was, I think, trying to take a little bit of the sting out of those nationwide injunctions and the perception that the court was taking a political position, at least with respect to the birthright citizenship order. And then, of course, she goes on having set up that less politically motivated kind of framework, and then she goes on and decides the case or explains the decision. But I just thought that that was kind of interesting, that clearly there's some members of the court who are squeamish about the shadow docket and the perception that it's it's a express route for the Trump administration to get the decisions that they desire.
I have to jump in for a second. I just have to say, it's also a way to give the Trump administration what it wants without writing a full opinion
Mm-hmm.
that might give that same benefit to a different administration.
Mm-hmm.
I would say, Bruce has a good point. I would say for those of the audience, what we're doing right now is familiar to you, handling a case. What would not be familiar to you is the shadow docket. That is completely different. Of course, I defended Obama's Clean Power Plan, which was one of the very first of the shadow docket issues, the last vote by Justice Scalia. But this is different. And as Bruce says, there's no opinion. It just comes out like magic from heaven there. So that's different. And I have no reason to think we're going to see less of it the term coming up.
And the other thing that's happened is the Trump administration has wholeheartedly embraced the unitary executive theory, which I think is absolutely wrong as a matter of constitutional history, because the very people who wrote the Constitution ended up putting restrictions on removal of executive officers in several instances when they ended up creating agencies. But they've made it pretty clear that they're going to overrule Humphrey's executor. And so basically they take the position, anything Trump wants to do with respect to the personnel of agencies, he should have the power to do, and anything that delays it from taking effect is irreparable harm, and we have cause to intervene.
So the Supreme Court doesn't take all cases. If you look at the numbers, they're staggering. We're in the thousands of petitions that are coming into the Supreme Court. And each year they take, maybe 70, 75. And so most cases, Supreme Court denies cert there. But we wanted to highlight 3 or 4 of them because for one reason or another, we thought they were significant, and we'll do these quicker there. I'll start. Utah versus United States. The United States owns about 2/3 of Utah. Utah has never liked that. Utah has done a number of things to try to claim ownership of the land that the United States has, and this is an example. It's also an example of something that we call it's an original docket. It's original jurisdiction. What does that mean? It doesn't go through district courts and courts of appeals. It's just a Supreme Court original jurisdiction case. A lot of the water cases you've seen in the past, state versus state, those are original jurisdiction case. Well, this is an example, but in order to get jurisdiction, you got to ask the court, pretty please, you file a complaint that says, pretty please, can I sue the other people? So Utah says, can I sue of the United States so I can get back 2/3 of my land, all the unappropriated land of Utah. The response to that was done during the Biden administration, and it was just like great history where the Solicitor General says, well, wait a minute. We got Utah because after the Mexican-American war, we bought it from Mexico for $15 million. And then, 10 years later, when we brought Utah into the United States, they had to sign as a condition of statehood that they would never challenge United States ownership of this land. And therefore, not surprisingly, the Solicitor General says, don't take the case. They didn't take the case, but it's probably, we will continue hearing these sorts of issues coming out of Utah because they feel strongly about it. Next case. I think this is mine too. Bob, I'm gonna do this, but then I'm gonna ask you because it fits into something that you've talked to before about all the climate cases going on. There's bunches of them going on. This is just one example. This is Sunoco case. The Supreme Court of Hawaii in the Honolulu case said that this would belong in the state court, not federal court. And the Supreme Court blessed that. But that's not the first of these cases, is it, Bob?
No, and they've been, in fact, Alabama is another really outrageous case where the state of Alabama just decided to sue all the blue states because they were permitting their state courts to hear climate litigation, like cases saying the fossil fuel companies violated consumer protection laws by hiding the fact that their products contributed to climate change. And the bizarre thing is there's just no legal grounds to they were asking the Supreme Court just make the blue states stop allowing climate litigation. And it's sort of part of the fossil fuel industry now has vowed we are going to crush all climate cases. And yet the problem is they don't have the legal grounds to do so. And what they had been arguing previously, the Clean Air Act, by preempting the federal common law of nuisance, should wipe out all common law nuisance suits against the fossil fuel industry, was premised on the endangerment finding that the Trump administration's repealing, which is one reason why the Edison Electric Institute and others have refused to back the idea that we should that the court should quash this stuff. And following this denial of original jurisdiction review, President Trump issued an executive order directing the Justice Department to sue the blue states because they're allowing climate litigation. You still have to have some legal grounds for quashing that. They're arguing it's all preempted. This is all a global phenomenon. It has to all be governed by federal common law. And the court majority has been very good at staying out of state tort litigation. It hasn't really crossed that boundary yet from the standpoint of federalism. So they've spent an unbelievable amount of money trying to get these cases into federal court, but generally the courts, with maybe one or two exceptions, have said that you just don't have the case on its face.
But why is that true, Bob? Why are they so adamant about trying to get it into federal court instead of state court?
Well, because they wanted to be able to say the Clean Air Act preempts because Clean Air Act displaces the federal common law of nuisance, that in federal court you can preempt these state cases. But there's no holding that the Clean Air Act, except for one Second Circuit panel, preempts it. That Second Circuit panel decision was based on there's a possibility of conflict, but there's no possibility of conflict if the feds have decided we aren't going to do anything to regulate greenhouse gas emissions. So it'll be interesting to see if this campaign. Notice back here, Justice Alito has to recuse himself most of these cases because he has the most extensive stock portfolio of any justice, and a lot of it is in the fossil fuel companies who are defendants in these cases.
Here's one where the court denied cert in the Port of Tacoma versus Puget Soundkeeper Alliance. In this case, the state of Washington, operating on delegated authority by the EPA, had issued a Clean Water Act permit to the port that contained conditions that were required by federal law, but also additional conditions that were authorized by state law that went kind of beyond the federal requirements. And Soundkeeper sued, and there was a dispute as to whether or not Soundkeeper could use the federal citizen suit provision that's in Section 505 of the Clean Water Act to get into federal court to sue based on these violations of state law. And the Ninth Circuit said, yeah, they could, that you could use the federal citizen suit provision to enforce any of the conditions in the permit. And then Port of Tacoma sought cert. Cert was denied, which means it leaves intact this lower court ruling that allows the environmental groups to kind of use this federal citizen suit provision to enforce those state law provisions. And so, and the petition raised a circuit split on that one. The Ninth Circuit recognized that there was a circuit split on that one. So this might be one that kind of comes back in another form, but the court didn't like this one.
So
Okay.
now we're starting the term that began in October. We're just into it right now. The Supreme Court has not filled out its dance card completely, so we don't know what the whole year is going to look like. But the two cases that are environmental cases before we do the significant non-environmental case, the tariff, they're significant cases, but the issues themselves are pretty much federal rule of civil procedure stuff. Both Enbridge and the next case I'm going to do, Chevron, are both dealing with whether or not this belongs in state court or federal court. The removal issues that we've talked to you a bit about. In this case, Michigan sued Enbridge because I'm from Michigan. They have Mackinac Island, and there's a wonderful place to vacation there, and underneath the water between the lower peninsula and Mackinac Island, Enbridge has a pipe. The Michigan has long thought this might fail, and so they sued Enbridge to make them pull it out. Enbridge, as you would imagine, is not happy about that. And one of the things they want to do is get this into federal court. There, they asked to do that. Supreme Court or the Court of Sixth Circuit disagreed, and the Supreme Court has taken that case. So it's a narrow issue. There. So is Chevron. Chevron's a different case. There, these are Louisiana parishes say that Chevron has adversely affected our wetlands, all of our coastal issues by what they have done. And Chevron said, wait a minute, I'm entitled to be in the federal court because I was a contractor. I was a contractor for the federal government, particularly during World War II. And therefore, that standard allows me to get into a federal court. But the one we're all watching right now, everybody's watching, there is the tariff case. Bob, what do you think?
Well, this was really interesting because if you believe in the major questions doctrine the court used in West Virginia versus EPA to dismiss the Clean Power Plan, if there's an action that has tremendous economic and political repercussions, the court has said it's not going to rule in favor of the agency unless the statute explicitly gives the agency the authority to do what it did. Well, in the tariffs context, there's a lot of statutes authorizing declarations of emergencies, but there's no law that expressly gives President Trump the authority to affect the entire world economy with these unprecedented tariffs. And the oral argument went so badly for the administration in the federal circuit that they subsequently sent this amazing letter to the judges saying, if you don't rule in our favor, we're going to have another Great Depression. Millions of people will be put out of work. And the case now has been argued before the Supreme Court. The argument didn't go very well for the Trump administration. And so you're hearing things like Scott Besson, I guess he's Secretary of Commerce, or is he Secretary of Treasury? He said just this weekend, I'm confident we're going to win this case, not because the law's in our favor, but because this is such an important signature initiative by the president. And the court always upholds administration signature initiatives. I guess you could make a case for that with respect to the Affordable Care Act case, where Chief Justice Roberts said it was something that could be allowed because it was a tax. But it's almost like as though what the administration is arguing is even if what we did was illegal, excuse me, even if we had no legal authority for it, we have to be allowed to do it. And that's kind of a sad state of affairs. I saw in the chat that Ruth Bell, hi Ruth, asked, given that there's so much against us in the Supreme Court and the like, how do we come up with new strategies to appeal to the justices? And I think this is an interesting example of it, the Apache Stronghold case. The court ultimately denied cert over a couple of dissents from Justice Gorsuch and Thomas. But what it involved a challenge to a land transfer that involved land that the Apache tribe thought was sacred to them. And what I liked about this case was that they're trying to take the court's penchant for wanting to restore religious liberty and use that to appeal to them to do something that would be good for the environment, not allowing this federal land to be turned into a giant copper mine. It wasn't successful, but it did get a couple of cert denial dissents. So,
Can I want to make sure we don't leave without addressing the big issue of the endangerment finding and what our panelists think will happen when it gets to the Supreme Court.
Well, I'll go first since I defended it when I was in the Justice Department, successfully, I might add, there as part of a number of the Clean Air Act initiatives. This is Lisa Jackson's signing something that we all thought was rather straightforward, and then, of course, got challenged but upheld there. What I didn't do in all my statistics is tell you that ordinarily the Supreme Court reverses 70% of the time. 70% of the time, if you see a case that is taken, they're taking it and they're going to reverse it. Very few, unless there's a circuit split, are they writing just for the fun of it there. So I think there's a pretty good chance that the Supreme Court will not take this case, assuming that the Court of Appeals does not invalidate. The record so far right now is abysmal in terms of creating a record that would allow you to overturn. And remember, Loper-Bright cuts both ways. Loper-Bright makes it harder sometimes to defend a regulation for the government, but it also makes it harder for the government to change a regulation. And so for all that reason, I think there's a substantial thing that the Supreme Court will not take the case, but if they do take the case, I do not think they will invalidate endangerment finding. Others might disagree.
This is going to be the mother of all legal battles. And, during the first Trump term, there was talk about reversing the endangerment finding, but I think the administration was wisely counseled, don't open this Pandora's box. And they've done so now. And their legal basis for doing so is really quite shaky. Because, do greenhouse gas emissions endanger public health or welfare? The case that the prior administration made for that is such that you'd almost have to deny all the science in order to affirm the administration's repealing of this. And of course, it's a double-edged sword because that gets rid of the legal argument as to why state climate litigation should be preempted.
Yeah, I'll just jump in and say, back when Massachusetts versus EPA was decided, and it was clear that, that an endangerment finding of some sort was going to have to be worked on. I remember a commentator saying, "Look, we've got the science," and this was back then. We've got enough science that my third grader could write an endangerment finding, right? And I think the science, to Bob's point, the science has only gotten stronger. And what I tell my students, because this came up under the first Trump administration, is let's look at that first endangerment finding. I mean, it took a while for the Obama administration to do it, in part because it's locked down on the science. It also, if you look at that finding, it talks about, even though it came up in the context of mobile greenhouse gas emissions, it talks about greenhouse gas emissions being significant from every sector. So it's I think a good piece of work, which means that if the court were to take it up, well, it would be hard pressed on, first of all, to think of how this administration would write a rollback of the endangerment finding that survives arbitrary and capricious review, right? Under FCC versus Fox, the Supreme Court has said, you review reversals the same way that you review something that comes out initially. And so this is going to have to survive arbitrary and capricious review. And if you remember back at the first Trump administration, there were some studies done kind of towards the end of that administration as to how many times the administration was getting reversed on arbitrary and capricious review. My sense is this one would fall into that camp, and the justices won't touch it because they're going to have to do backbends, I think, in order to uphold a reversal on this part. But maybe that's the non-cynical view where the rule of law governs. But I think that I do think that the Obama administration did a fine job with that finding and have insulated it from attack. So that one will be interesting. I agree that it's going to be a hard fought battle, but I'm hopeful.
Yeah. Well, and what the Trump administration tried to make it look like, we're taking a fresh look at all the science, and they appointed this small group of climate skeptics to kind of cherry pick prior science and say, nah, it's not, climate change isn't really that bad, especially if you consider all the economic benefits we'll get if we don't regulate greenhouse gases. But the problem's been that the very studies those panel members cited in their report, the authors of those studies, several of them have said they've totally distorted my scientific work. So it really looks like a kind of cherry picked document that they've created. And if the justices decide to throw in their lot with the Trump climate deniers, now it's not to say that Bill Gates's statement about climate change is not an existential threat might change the mood. Like, well, maybe we've been sold a bill of goods, but even he who wasn't saying it's not endangering public health or welfare, it's not going to kill us all, which of course is probably true. But this will be probably one of the most significant, and it will take a while though, because it's going through the DC circuit first. So.
All right, you heard it here. Some optimism. It's hard to have optimism these days, but we're hearing it expressed. The only question I have, unless somebody wants to, any panelist wants to add something else, is somebody in the audience would like to go back to the waters of the United States definition. And of course, one thing is, where do we go from here on waters of the United States? Maybe we can quickly restate what happened and then give a sense of where the panelists think we're going on this issue.
Well, I can jump in there and just kind of remind us that when it comes to Sackett, right? Justice Alito writes this. Well, he doesn't write, but he accepts what was the narrower reading of waters in the United States, rejecting the significant nexus test and telling us that we're going to need a superficial hydrologic connection, and suggesting that we're going to have the jurisdictional reach limited to wetlands that are more spatially more hydrologically connected to traditional waters of the United States. And one of the major concerns after that opinion was kind of the gap that it left, where a number of states did not have laws in place to regulate wetlands that were outside of that reach. And so I think that there's ongoing concern that that there's going to be gaps left by the Sackett opinion in some states, not others. Like here in the state of Washington, I've spoken to some folks that work on those issues within our AG's office, and we're less concerned because our state happens to have a stronger wetlands protection laws through the state. So I think we're going to continue to see a patchwork approach on wetlands in the short term, especially at the a patchwork among the states, which is disappointing considering that we can't necessarily reverse some of the damage that is done. And I will say, I think that's where the Supreme Court gets their calculus a little bit wrong on some of these statutory interpretation issues, because Congress doesn't amend and pass legislation as quickly as the judiciary could commit statutory interpretation errors, right? So in the meantime, we've got gaps that are left and wetlands that are unprotected. And so I think it's an incomplete answer if you're the court thinking, oh, well, it was just a statutory interpretation issue and Congress could go back and fill that gap.
Yeah.
I don't know.
Well, the Trump administration's zeal for rolling back regulations is so great. They're just insatiable, and it often leaves them in uncomfortable positions. I think one of my favorites is they announced that incidental takes of birds were fine, but then because Trump hates wind power so much, they said, "Oh, but that doesn't apply if the bird's killed by a windmill. We're going to prosecute those cases criminally if a bird's killed in an incidental take by a windmill." I mean, you cannot reconcile those two positions.
On Wotus, Citizen, completely right. When I'm teaching this to my class, though, I show the map that's on the EPA website, where it shows by color coding what law applies in that state, right there, because of course you invalidated the Biden era rule. Well, just in the last few days, Trump has come out with a new proposed waters of the United States. I have every reason to think that too will be litigated just like everyone else has been litigated. And this will not be in just the DC Circuit. The waters of the United States, by Supreme Court decision, goes to individual circuits. So we're about to see more chaos in an area that already is full of uncertainty.
Well, I want to thank the panel. We've run out of time. This has been an extremely informative discussion, and I think the audience, certainly I have learned a great deal. And so I appreciate your taking time from your busy schedules and your rehabs or whatever it is you're doing right now, and helping us out in this way. Thank you all very, very much.
Thank you for having us.
Our pleasure.